Virtual Lesson 5.3 International Law and Common Heritage Territorial Issues. It is easy to understand why the land masses of the earth have been carefully divided among nations. Control of land is linked to resources and power, and the drawing of fixed boundaries is important to settle and prevent disputes. However, certain zones and resources of the earth have historically been viewed as beyond the control of individual states and rightfully belonging to the world community, such as the high seas, Antarctica, airspace, and outer space. The approach has generally been that these zones should be shared and developed for the benefit of all humankind. With advancements in technology, though, such as those in the areas of transportation and resource extraction, some countries are making claims that would encroach upon these zones for various reasons. International law, then, must achieve a balance between the opposing notions of state sovereignty and the global community. Canadian boundaries. Canada and the U.S. share the world's longest border. It provides a good example of the complexity of determining borders and the legal rights associated with them. The land boundary between the two countries was only established after at least 17 agreements and a number of international commissions and arbitrations. The International Boundary Commission was created in 1925 to preserve the integrity of the boundary through surveying, mapping, clearing vegetation, and maintaining markers and monuments. The position and interpretation of land boundaries will also have an effect on the adjacent water or maritime boundaries, which can be very contentious due to the issues related to shipping, fishing, and natural resources. In general, states have sovereign rights over the territorial waters or territorial sea that extends for 12 nautical miles off their shores, as provided for by the United Nations Convention on the Law of the Sea, 1982. As recently as 1984, Canada and the U.S. were at odds and turned to the International Court of Justice to delineate a maritime boundary through the Gulf of Maine, and still to this day, ownership of Machias Seal Island, located in the Gulf, is disputed. Also, as discussed in a previous unit, the determination of maritime rights in the Arctic will be a contentious issue for years to come. Antarctic boundaries. Very little political interest was shown in Antarctica prior to World War II. Then, during the Cold War, there was a much greater push toward exploration and territorial claims. In 1959, a number of countries signed the Antarctic Treaty, which was an agreement to suspend national claims in order to pursue the goals of environmental protection and scientific openness. It was understood that signing did not prejudice any future claims that the countries might make on the territory. In the 1980s, after the potential for resource extraction in Antarctica became apparent, negotiators began to draft the Convention on the Regulation of Antarctic Mineral Resource Activities, 1988, which created a framework for the extraction of mineral resources. Environmentalists were outraged by this, and the ensuing international pressure led to the scrapping of the convention and the negotiation of the Protocol on Environmental Protection to the Antarctic Treaty, 1991, which embodied a commitment to peace, science, and environmental protection with a specific prohibition against mining for at least 50 years. The oceans. The doctrine of non-appropriation. Dating back to the first times when the issue was seriously considered, oceans and seas were believed to be open and shared by all nations. This is the doctrine of non-appropriation, which stated that the water beyond coastal territorial waters, referred to as the high seas, shall not be subject to the sovereignty of any particular state. This view was held by the ancient Romans, and in 1609, the Dutch lawyer Hugo Grotius affirmed it in his book Free Seas. Grotius is considered to be the father of the law of the sea. Modern maritime zones. The doctrine of non-appropriation reflects the technology of the past, which in practical terms did not allow for meaningful control of the high seas, and also the military and commercial interests of the dominant powers of the time. In modern times, there has been more debate with respect to the competing interests of coastal states and the international community. This has resulted in an increasing trend of appropriation of marine resources by powerful coastal states and the partitioning of oceans into maritime zones, each with its own set of rules that represent a compromise between the rights of coastal states and the international community. The first maritime zones were created as early as the 1700s by the cannon shot rule, which provided for sovereignty over a 3 nautical mile band of water off the coastlines of each country. This distance was roughly equivalent to the range of land-based cannons at the time. Innocent passage was allowed through these territorial waters for the purposes of exploration and shipping, but not for fishing, threatening military maneuvers, or any other illegal activities. With respect to security and defense, states were permitted to pursue any vessel alleged to have committed piracy, both in territorial waters and on the high seas. Similarly, if a vessel was alleged to have committed any offense in territorial waters, a state had the right to continue pursuit of it into the high seas, according to the doctrine of hot pursuit. The complexity of these doctrines is well illustrated by the case of the sinking of the I'm Alone, which involved a 1929 incident in which a U.S. Coast Guard cutter deliberately sunk a Canadian-registered schooner accused of illegally transporting alcohol. A joint Canada-U.S. commission later ruled that the U.S. actions were illegal since they did not properly exercise the right of hot pursuit before the attack. After World War II, U.S. President Harry Truman unilaterally extended American jurisdiction over all natural resources beyond the cannon-shot 3 nautical mile band to include the continental shelf, which is the area above the outward-sloping continental landmass until it reaches a depth of 200 meters. Other countries soon made similar claims of sovereignty over their continental shelf. Under this definition, Canada's continental shelf is massive, extending up to 1,000 kilometers from shore, and it asserted control over all of it. This met with criticism that Canada and the other countries with large continental shelves, the US, Australia, and Russia, are developed and already control a disproportionate amount of the world's resources. Modern times have created other reasons for maritime states to wish to extend the limits of their territorial waters: pollution and diseases from passing ships, surveillance technology that would allow passing ships to eavesdrop on land-based installations, customs and immigration violations, and advances in the fishing industry that resulted in vessels with tremendous capacity depleting fish stocks. This led many countries like Canada to establish special purpose zones of jurisdiction to facilitate the enforcement of their laws. The international community will typically accept such zones if they appear to be made for legitimate reasons. However, in some cases, opposing interests have clashed. For example, limits set on fishing off a country's coastline may be viewed as an unacceptable, self-serving act by countries who depend on fishing as an important source of food and income. The United Nations Convention on the Law of the Sea. By the late 1960s, there were a number of threats to the state and the future health of the oceans and the deep seabed, which refers to the seabed or ocean floor beyond the limits of sovereign territory. The harvesting of resources including fish, oil and gas, diamonds, metals, and minerals had reached new heights. Nuclear technology, including weapons testing and submarines, and the threat of oil tanker disasters, such as that of the Torrey Canyon in 1967, were international concerns. In late 1967, the Maltese ambassador, Arvid Pardo, made a moving speech to the General Assembly of the United Nations, in which he outlined his belief that the deep seabed is part of the common heritage of mankind and must be protected. In response, and after many years of negotiation, the United Nations Convention on the Law of the Sea was passed in 1982 and implemented in 1984. To date, 161 countries have ratified the convention. The convention widened the band of territorial water to 12 nautical miles offshore and also established another 12 nautical mile contiguous zone. adjacent to territorial waters wherein coastal states had wider powers to police and enforce laws. The convention clarified the doctrine of innocent passage by providing for transit passage, which allows uninterrupted navigation and overflight in and above international straits narrower than 24 nautical miles. The convention also confirmed the international law with respect to internal waters, granting sovereign rights to formations such as bays, gulfs, and straits along the shore of the country's mainland. The convention also established exclusive economic zones, or EEZ, that extend 200 nautical miles from the shores of coastal states. Within the exclusive economic zone, the coastal state enjoys exclusive control over resource exploitation and environmental management, thus greatly reducing the size of the area designated as the high seas. This was a shift that was welcomed by most Canadian interests, and the federal government asserted Canada's exclusive economic zone with the passage of the Oceans Act in 1996. It is generally believed that the exclusive control that comes along with EEZs will lead to more responsible management over both natural resources and the environment, due to the closer connection between the decision makers and the people who are ultimately affected by those decisions. However, the notion of exclusive economic zones does run counter to Pardoe's concept of the sharing of the seas as the common heritage of mankind, and raises the concern that it may play to the favor of the more powerful, developed countries, which may be able to make better use of their zones. The convention also redefined the continental shelf that falls under the control of the coastal state. The line is to be drawn between 200 and 350 nautical miles from the shore, depending upon the topography of the area. In general, the coastal state has the right of exploitation of the region of the continental shelf that lies beyond the 200 nautical mile exclusive economic zone, but it must make payments to a World Community Fund as a form of compensation. The requirement of making payments was a concern for Canada due to the Canadian interests in the oil fields that were operating beyond the 200 nautical mile limit off the shore of Newfoundland, Hibernia, and Terra Nova. It was primarily for this reason that Canada did not ratify the convention until 2003. Specific issues with fisheries. Canada generally has not viewed the 200 nautical mile exclusive economic zone to be adequate with respect to fisheries. This is largely due to known behavioral patterns of certain types of fish. Straddling fish stocks include species that swim from the ocean into freshwater bodies of water to spawn, such as salmon. Highly migratory fish stocks include species that are known to travel great distances in the sea, such as tuna, shark, marlin, swordfish, and sailfish. In 1994, Canada amended the Coastal Fisheries Protection Act in a bid to exert control over these extended areas. In 1995, Canadian officials boarded the Spanish fishing vessel Estay, which had been fishing in contravention of the legislation. This led to a controversial international incident which was finally diffused by the signing of the UN agreement relating to the conservation and management of straddling fish stocks and highly migratory fish stocks, 1995. The issues relating to fisheries are so complex that, in addition to the agreements already discussed, numerous treaties have been needed to settle disputes between particular nations. The final issue to consider is that regardless of how the rights over fisheries have been settled, it is feared that much more effort is put into exploitation than protection and conservation. In response, the UN has launched a number of initiatives to try to reverse the global depletion of fish stocks. The ultimate success of these initiatives remains to be seen. Airspace. The earliest approach to the use of airspace was that it should be relatively free and open. In 1911, the Institute of International Law, which is a private association of renowned international lawyers, proposed the following as a basis for an international convention. Aerial circulation is free, saving the right of subjacent states to take certain measures to ensure their own security. Unfortunately, a few years later, the aerial bombing that started taking place during World War I made it clear that more restrictive measures were needed. After the war, in 1919, an international convention declared that each country was to have absolute sovereignty over the airspace above it. This principle was reaffirmed in 1944 by the Chicago Convention on Civil Aviation. The exclusive sovereignty includes the airspace above the territorial waters of coastal states. At the same time, a doctrine similar to that of innocent passage on the seas developed to facilitate the growth of civil aviation. There have been incidents of foreign aircraft being shot down while flying through the airspace of other countries. In some cases, they have been proven to be spy planes, but in others, they have been innocent civilian planes which had maybe flown off course. In response to one such downing of a civilian jumbo jet, the international law was changed to forbid the use of weapons against civilian aircraft suspected of spying. Instead, the home country must demand that the aircraft land and comply with local regulations. The Chicago Convention on Civil Aviation established the International Civil Aviation Organization, or ICAO, a UN agency based in Montreal and responsible for administering the international civil air travel system. As part of its mandate, the ICAO administers the Montreal Convention, which deals with the safety of civil aviation. The convention makes it an offense to threaten or commit any acts that endanger the safety of civilian aircraft and requires states to cooperate with each other with respect to prosecution. After the terrorist attacks of September 11, 2001, the ICAO resolved to make an action plan to secure civil aviation against such threats. This included mandatory evaluations of the levels of security in place for all member states, which now number 189. Many of us have experienced the stiffer, ever-evolving, and often annoying airport security measures that have been in place since 2001. Outer space. Starting in the 1960s, international law had to quickly adapt to the new prospects of space exploration and travel. Since then, the United Nations has adopted 5 declarations of legal principles, which for the most part encourage cooperation and non-appropriation. Declaration of Legal Principles Governing the Activities of States in the Exploration and Use of Outer Space, 1963. The Principles Governing the Use by States of Artificial Earth Satellites for International Direct Television Broadcasting, 1982. The Principles Relating to Remote Sensing of the Earth from Outer Space, 1986. The Principles Relevant to the Use of Nuclear Power Sources in Outer Space, 1992. And the Declaration on International Cooperation in the Exploration and Use of Outer Space for the benefit and in the interest of all states, taking into particular account the needs of developing countries, 1996. The following space law treaties have been widely ratified and are currently administered by the United Nations Committee on the Peaceful Uses of Outer Space. The Treaty on Principles Governing the Activities of States in the Exploration and Use of Outer Space, including the Moon and other celestial bodies, 1967, otherwise known as the Outer Space Treaty. The Agreement on the Rescue of Astronauts, the Return of Astronauts, and the Return of Objects Launched into Outer Space, 1968, also known as the Rescue Agreement. The Convention on International Liability for Damage Caused by Space Objects, 1972, otherwise known as the Liability Convention. The Convention on Registration of Objects Launched into Outer Space, 1974, otherwise known as the Registration Convention, and the Agreement Governing the Activities of States on the Moon and Other Celestial Bodies, 1974, also known as the Moon Treaty. Another important treaty, signed in 1963 by only the Soviet Union, the United States, and the United Kingdom, is the treaty banning nuclear weapon tests in the atmosphere, in outer space, and underwater, also known as the Nuclear Test Ban Treaty. Despite the existence of these declarations and treaties, there are still a number of developing issues with respect to space exploration that have yet to be settled by international law. They include mining rights to the Moon or other celestial bodies, the use of nuclear power in satellites, the militarization of outer space, the proliferation of space junk, jurisdictional issues with the International Space Station, and establishing the vertical boundary between sovereign airspace and outer space. Environmental issues. The atmosphere. Small changes in temperature can have drastic effects on the delicate ecosystems of the Earth. Environmentalists have pointed to increasing levels of greenhouse gases as a major cause of global warming. Greenhouse gases are those in the atmosphere that absorb and emit heat energy, such as water vapor, carbon dioxide, nitrous oxide, and methane. Many human activities have led to these increases. The burning of fossil fuels produces carbon dioxide, methane, and nitrous oxide. Deforestation leads to increased levels of carbon dioxide, and the farming of livestock results in concentrated emissions of methane. By its very nature, the atmosphere is a shared resource, and it is easy to argue that its protection should be taken up by the global community as a whole. In 1988, the World Meteorological Organization and the United Nations Environmental Programme established the Intergovernmental Panel on Climate Change, or IPCC. The IPCC is responsible for collecting data, researching causes and effects, and predicting future rates and consequences of climate change. The 1992 report released by the IPCC led to the adoption of the UN Framework Convention on Climate Change. This framework, in turn, called for international conferences to be held as a means of discussing global strategies to address the problem. One such conference, held in Japan, led to the drafting of the 1997 Kyoto Protocol, negotiated by over 160 countries, which contained a complex plan to reduce greenhouse gas emissions for each country to, on average, 5% below their 1990 levels by 2012. The protocol came into force in 2005 once enough countries had ratified it. At present, 191 states have ratified the Kyoto Protocol. However, a much smaller number of countries have actually committed to reducing emissions. The United States, which is the largest per capita producer of greenhouse gas in the world, has not ratified the protocol, and at this point seems to have no intention of doing so. The Kyoto Protocol established a complex mechanism by which countries can earn, trade, and sell carbon credits, which can be offset against actual emissions to help them meet their Kyoto targets. Countries earn these credits by undergoing environmentally friendly activities in other countries, such as assisting in a switch to wind or solar-generated power. Despite this generous mechanism, many countries failed to meet their 2012 targets. Although climate change is a very popular cause, there is resistance to taking strong measures to reduce emissions from many provincial governments and business groups. They argue that placing restrictions on business activity is too high a price to pay to try to slow down climate change, especially when the science behind it is questionable. For this reason, it is important that NGOs like Greenpeace continue to operate to raise awareness of environmental issues without the influence of fiscal considerations like tax revenue or profit margins. The ozone layer. The ozone layer forms part of the upper atmosphere, lying roughly between 15 and 35 kilometers above sea level. It protects life on Earth from the damaging effects of ultraviolet radiation. Due to the use of chlorofluorocarbons, or CFCs, in refrigerators, air conditioners, cleaning solvents, and aerosol sprays, the ozone layer has been depleted with some large holes developing over Antarctica and the Arctic. Holes allow greater amounts of ultraviolet radiation to reach the Earth's surface, which can result in the destruction of animal habitats, the extinction of species, and human health problems such as skin cancer and cataracts. An international convention entitled the Montreal Protocol on Substances that Deplete the Ozone Layer was adopted in 1987. The Montreal Protocol set targets for the reduction of CFC use by all participating nations, which now include all members of the United Nations. This is one international initiative that has proven successful. For the most part, individual nations were able to meet their targets, and the use of CFCs decreased significantly. It is now believed that ozone depletion has been halted and that the holes in the ozone layer are closing, although full recovery might not be achieved until the middle of this century. Fresh water. Another environmental issue that is of particular interest to Canada is the sharing of the world's freshwater resources. Canada is home to 0.5% of the world's population, but enjoys 7% of the Earth's land mass and 9% of its fresh water. There is currently much debate about the question of whether to divert or ship fresh water to other nations for either economic or humanitarian reasons. Supporters of the concept point to the fact that we have more fresh water than we need, and detractors generally raise the concern that depleting the existing level of fresh water in any particular body of water would have detrimental effects to the local natural or human habitats and possibly even beyond. The reality is that Canada's policies will likely always reflect a compromise between these two positions. It would be difficult to institute an outright ban on the export of fresh water out of the country due to Canada's participation in NAFTA and GATT.